broadcast now. Welcome dear colleagues, candidates and the public. Today is on January 21st, 25, the advisory group of experts meets to conduct an interview with a candidate for the position of the judge of Constitutional Court of Ukraine, Alla Sanduliak. All 6 members of AGE are attending the meeting: Mr. Aleš Zaler, Vasil Shekun, Yaroslav Romaniuk, Anna Sukhotska, the secretary of AGE, Maureen O'Connor, and me, the head of DG, Oksana Vasilchenko. The deputy members of AGE are attending as well: Volodymyr Kuzmenko, Marek Zubik, Richard Barrett, Thomas Griffiths, and Vitaly Makhinchuk. I have to note we are working in a shelter, so in case of an air raid announced, the interviews would continue uninterrupted. I remind you also that the interview is being recorded and broadcasted live on the resources of the AG and the Constitutional Court of Ukraine. I draw the attention of the members of AG and the candidate to the restriction of the use of sensitive data and information with restricted access in a live broadcast. In case of discuss such issues, the AG will suspend broadcasting by that time. We are ready to begin. I give the floor to Maureen O'Connor for introduction of the candidate and reminder of the interview schedule. Please, Maureen.
Thank you, Madam Chair. Greetings, colleagues. Good morning to all those who are watching our proceedings this morning. As our chair has already said, the advisory group of experts will now conduct an interview with Canada Madam Alla. Let me remind you that the interview is a mandatory step. The opportunity for the candidate to come and be interviewed at the candidate's discretion is a mandatory stage of evaluating the candidates as part of assessing their compliance with the criterion of high moral qualities. Our interview will last approximately an hour. And the time limit for answering questions that are posed within the interview is no more than 3 minutes. We ask all candidates to be concise, to answer clearly, unambiguously, and to answer the essence of the question that has been asked. In the interview, the candidate can make a short final statement of no more than 5 minutes. I would also like to note that during the processing of materials about candidates, each candidate receives questions provided by the AGE, and the request is to provide written explanations. So the candidate has had the opportunity to prepare and to provide answers with regards to the subject matter of this interview. So now we have with us the candidate for the post of judge of the Constitutional Court of Ukraine, Alla Sanduliak, who was admitted to the competitive selection by the Competition Commission under the President of Ukraine. She is a prosecutor of the 3rd Department of the Department of Organization and Procedural Management of Pretrial Investigation and Support of Public Prosecution in Criminal Proceedings of the security agencies of the Department for Supervision of Compliance with Laws by Security Agencies of the Prosecutor General's Office. That is the qualification of our candidate. And Madam Alla, if you want to add anything about your qualifications that I have not mentioned in this introduction, you may do so now for up to 3 minutes.
Thank you, dear experts. On top of being the prosecutor of the prosecutor's office, in my professional activity there was also a teaching activity, academic activity, and lawyers or advocates activity. So in this case, I believe I have sufficient professional experience in a law enforcement area, also regarding the constitutional regulations. Thank you. Dear colleagues, please ask questions to the candidate.
Madam Sanduliak. I will start with a question which relates to non-declaration on the right of ownership and the right to use real estate objects. Your husband, Mr. Sanduliak, is the owner of 1/5 of a residential building of 103.6 square meters, so 103 square meters in Ternopil region in Podillia village. And you declared different dates of acquisition of the right of the joint ownership of residential building. In the declaration for 2017, the date of acquisition of the right of joint ownership is indicated as 22nd of January 2002. While in declaration for 2020, there's a date of 24th of May 2012. So that's quite a big difference. And what was the real date of acquisition of the right of joint ownership of the residential building? We want to clarify this.
In 2017, when I submitted the declaration being a candidate for a relevant position, I submitted the date which were noted in the relevant document. And that official document was marking the date of decision taken on the right of ownership right, and also the reason and the decision of the relevant municipality, of the relevant territorial community was there with the relevant date. But according to the later explanation by NACP, it was said that the date of registration of the ownership should be shown, not the date of the decisions, which serve as a ground for registration of the ownership title. That is why the difference is there. But when submitting declaration in as a person in the functions of a civil servant, I submitted the data which were indicated by an SCP as relevant and obligatory to be in the declaration. Thank you. So this was kind of a correction.
Registration conducted 10 years later. So instead of 2002, it was done in 2012. Is my understanding correct?
Tak.
Yes, yes, it is so. So, according to the explanations provided by an ACP, the date of registration of ownership should be indicated, not the date of the decisions serving as a ground for ownership. Uh, According to the legislation of Ukraine, the ownership, as the reasons of the ownership can be different legal facts, but the moment of registration is connected with the procedure of state registration. So that is why this period of time is so long and is different.
You declared this in the year 2020, but then you did not indicate information about this house in your subsequent declarations for the years 2021, 2022, and 2023. Also, this information is not in your husband's declaration for 2022 and 2023. Could you explain why you did not indicate this information in the declarations?
Dear experts, subsequently, accordingly, my husband does not have the share under the right of ownership. In 2019, once he also privatized a share of the land plot, he committed actions with respect to the transfer of this share in the house and land plot to his mother. based on the deed of gift. Since it was the house and the land plot where his mother lives, she uses this land plot, so that is why my husband does not live there and he does not use it, so he decided to do that. So that is why subsequently in my declarations this object was not declared because my husband did not have the right of ownership for it. Thank you.
When exactly he entered this deed of gift?
2000
In 2019.
Thank you. Next question. According to declarations for 2019 and 2020, on 12 June 2019, your husband acquired into joint ownership, in fact 20%, a land plot with an area of 2,500 square meters in the village of Podilia. At the same time, information about this land plot is not in your declarations for 2021, 2022, and 2023, and your husband's declarations also for the period from 2022 to 2023. Can you explain this?
Dear expert, I have just answered this question. In 2019, once my husband acquired the share of the land plot into ownership, accordingly he gifted this share of the land plot and of the house to his mother. And that is why he is no longer the owner of the land plot or the house. And in connection with this, there were no grounds to declare property that is not owned by my family members. Thank you.
Thank you. So we are speaking about the same land plot and the house, right?
Так.
Yes, yes.
Okay, thank you. In the declarations for a period of 2019 to 2023, you declare a family member, your husband, and indicate that he receives income from Donetsk Regional Prosecutor's Office, which has temporarily changed its location, and it's located in the city of Dnipro. At the same time, you did not indicate the real estate that your husband used at the place of work. Why?
Since 2019 until now, my husband has been a prosecutor of the unit of the Donetsk Regional Prosecutor's Office. In 2019, accordingly, he lived in Mariupol since 2022 and since summer. He has lived during work in Dnipro. And during the days off, during vacation, he lives together with me in Kiev. Why objects were not declared? Since my husband from time to time rented together with his colleagues different accommodation options, and in connection with that, according to the NCP's explanations, it is clearly stated that if the person does not live in a real estate object for over 6 months, that is for over 183 days, the person is not obliged to declare this real estate object, but the person shall declare the place where he or she is as of the 31st of December. Since my husband occasionally rented different types of accommodation and he also used services of hostels, so accordingly other real estate objects there were not declared. Thank you.
Let me clarify something with you, because you said in your answers to the request of the advisory group of experts that your husband's actual place of residence was a dormitory in the city of Dnipro. And this dormitory he lived in since 2019. So now you are saying that he lived in a different places. So you change your position, you change your explanation, or is this just a reason to somehow justify why this fact was not declared?
You have misunderstood me. Since 2019 until 2022, before the start of the full-scale invasion, my husband lived in Mariupol because the Donetsk regional prosecutor's office was located in the city of Mariupol. He did not have a permanent object where he resided there. These were like occasional premises rented out by him, including hostels, since the official accommodation was not provided. Since 2022, he has worked in Dnipro, and also accordingly until 2024 he used different types of residential premises, and only since 2024 he started living in a dormitory that I declared. And this place of residence, as it exists now for over 183 days, it will be declared by him in the declaration that will be filed for 2024. This problem is related to the fact that, according to the legislation, prosecutors should be provided with service accommodation, but in reality it is not provided. And accordingly, the situation with accommodation is quite difficult.
Yes, I understand. But you should clearly indicate in which places and how long your husband lived, that we could check whether you were compliant with the requirements from the laws regards the declaration. So can you explain in which places he lived? These were hotels, or what places he took?
These were rented temporary apartments where they rented it for a month or 2 months. These were hostels where they lived depending on the period of time, not for a long period of time, different hostels. And accordingly, the last place of residence is a dormitory.
Okay, thank you. I will pass the floor to my colleague, Mr. Vasil Shakun, who will continue with questioning.
Let's come back now to ownership that you have. According to your declaration of a candidate for 2023, since the 8th of July of 2003, you have owned an apartment with a total area of 56.7 square meters in the city of Chernivtsi, valued at 14,906 hryvnias, which you acquired based on the deed of gift dated the 8th of August of 2003, concluded between your aunt Rudenok, Olga, and you. What is your relationship with your aunt that your aunt has been so generous in gifting you this apartment? My aunt does not have a husband and children. The only heir that she has is me. And in relation to that, she gifted this property to me. Where does she live now? She lives together with my mom, since they are both retired. Where do they live? In a village in Chernivtsi region. Okay, clear. Look, there is such a minor problem that you have, and that is related to court cases. The Commercial Court of Chernivtsi region on February 8 of 2021 satisfied your claim and cancelled the decision of the board of the Homeowners Association Haidar in the city of Chernivtsi, with which you were restricted in the use of utilities because of the failure to pay for utilities. Hence, according to materials of this decision, during 2016 to 2018, you did not make any payments to pay for provided utilities, which leads to a violation of rights of other co-owners in the building. Can you explain this? Dear experts, with respect to failure to pay for utilities, the decision of the commercial court was stating that my rights were violated by the homeowners association with respect to all non-payments. In this case, the civil legislation is in force. If I had any debts regarding payment of utilities, then the homeowners association would file a claim with the court to collect this debt from me through the court order. The court order is adopted by the court within 10 days. But the problem is different. The problem is that since becoming a member of the homeowners association, I made payments. In particular, I made payments that have to be aimed at the planning of the adjacent territory, and since the homeowners association did not check the indicators of meters, I paid much higher amounts than the utilities I used. In this respect, I addressed the homeowners associations many times in order to perform the recalculation of the funds that I paid. The homeowners association refused to do that, so I addressed at the general meeting of the homeowners association members. I also involved attorneys who addressed the homeowners association. Once attorneys have started sending requests to the homeowners association, the head of this association stopped responding to all of these requests. At the general meeting, I was told to recalculate everything on your own. Since I paid much higher amounts than the services I used for 5-6 years, I provided calculations about the amount of funds that I paid additionally, but it was not considered. I submitted applications that if they believe that I used more services than I paid for, then I asked them to address me with an official demand. I did not receive any official demands. The only thing is that by means of threatening me, they try to force me to pay higher amounts than the services I used. In connection with this, in this instance, I took all possible measures set out by the legislation, including filing a claim with the court. Thank you. So you got scared and you recalculated everything. No. First of all, their methods of threats included like alleged decisions of the homeowners association management in order to make me pay more than I used. Secondly, they shot at my windows and criminal proceedings were initiated. Okay, my next question is the following. Can you please tell us who lives in this apartment now? Dear experts, no one lives in this apartment as it is not suitable for living, and I will explain why. Now, the case is with the European Court of Human Rights, as non-residential premises located close to this multi-apartment building are being used by the polygraphic institution. They have warehouses there, so there is a lot of noise produced there, and there is also dangerous waste for this institution. And now the case is considered by the European Court. Thank you. And what is the status of this apartment? Were you gifted an apartment? Yes, I was gifted the apartment, but a few years later it became impossible to live there. I cannot sell it as well because no one would buy property that cannot be used for living. And how did your aunt live there? I'm telling you. The apartment was suitable for living until this institutions started its manufacturing nearby. Okay, clear. In addition to participation in the competition for the position of a judge of the Constitutional Court, you also take part in the competition for the position of the Court of Appeal. What is your motivation for participation in these competitions? My motivation is that I strive towards professional development. In this case, I believe that professional development can be ensured by the court system. As I have already passed the stages of teaching, attorney's activity, prosecutor's office, so now I believe that my highest professional development as a lawyer can be in the court system only. Look, the criminal specialization under which you have applied to become a judge of the court of appeal is somewhat different from the Constitutional Court. Dear experts, I understand accordingly that there is a difference, but in this case I believe that I have sufficient professional level in terms of applying laws, and this level allows me to take part in this competition and be a worthy candidate for the position of the judge of the CCU. You've just mentioned that you used to teach. Yes. Which discipline and where did you teach? I taught civil law in Western Ukrainian Economic and Legal University of Ivano-Frankivsk. Did you live there? This university was located in Ivano-Frankivsk. Its department was located in Chernivtsi, so accordingly I worked in Chernivtsi, but at the same time in Ivano-Frankivsk. We were provided with transportation to get to the place of work. Do you have the academic degree? No, I do not have it. And which publications do you have? Only those publications that I had while working as a lecturer, and I do not have any other publications. When you were a lecturer, which publications did you have? These were publications in academic practical seminars where I took part. In collections of materials. I'm not clear about that. What do you mean, this academic practical seminar? Like international practical academic seminars. Pursuant to their results, there are published collections of materials. Accordingly, my publications were there. Okay, clear now. It's clear that it's not clear. Okay, thank you. Thank you for your answers. Dear colleagues, do we have any more questions to the candidate? Yaroslav, yes, please. Alla, with the ruling of the 1st May City Court of Chernivtsi, dated 2019, it was stated that you, as the attorney of the defendant under the criminal case, provided recommendations to the defendant to ignore summons to the court, which resulted in the delay of the consideration of the criminal proceeding. The court considered such recommendations of the attorney as a violation of the attorney's ethics, and the commission of the bar commission was notified about that. Please comment whether you really provided such recommendations as the attorney for your defendant, and if yes, in your opinion, does it comply with the rules of professional ethics for attorneys? I have provided a written answer to this question. I will explain in more detail. When you defend a person, accordingly you are bound by a legal position of this person. And if this person says some things in the court which are not accurate, you cannot contradict that. No, we are talking about recommendations to ignore summons to court. I have not finished. I have not finished my position yet. Please listen to me. Accordingly, when our client, who was under home arrest as an interim measure, without informing the court or us, his attorneys, he went abroad and he failed to appear in the court hearing. And that was a ground that if the court finds out about his trip abroad and failing to come to the court hearing, then the interim measure would be changed to arrest. Our defendant could not make up anything else but to say in court that attorneys told him that they would be busy in another court hearing, and that's why he failed to appear. Accordingly, the court so it was not accurate. Yes, it was not accurate. That was verified by the Qualification Disciplinary Commission of the Bar. Our client came to a meeting of the commission and informed the commission that it was his way to protect himself against a more harsh interim measure, and he had no other options what to do. So accordingly, the court's ruling regarding bringing us to disciplinary liability was not satisfied. Okay, clear. Thank you.
Dear colleagues, any more questions to the candidate? If there are no more questions, we ask you, Alla Vassilievna, you have about 5 minutes for your conclusion statement. Thank you, dear group of experts, for this opportunity to participate in the competition. It is a great honor for me. I do believe that the position of the judge of Constitutional Court is the highest level in the career of any worker of law. So I thank you for this honor. Thank you. Thank you, Alla Vassilievna, for your answers. Dear colleagues, dear public, with this, the interview with the candidate for the position of Constitutional Court of Ukraine, Sanduliak Alla Vassilievna, is now